Hello, everyone, and welcome back to the Rebuttal podcast, where we break down case law, comedy, and of course, chaos in the legal field. I am your host, Reb Maisel. After a bit of a break from doing this, life got crazy. The world has been crazy, is crazy, will be crazy. I am here and back to talk about a case that is, as you will note, completely, totally unrelated to current events. Wink, wink, nudge, nudge, smile, smile. Nod at the camera and wave even, okay? Obviously, during that short hiatus, I was not getting my roots done. I don't want to hear it. My appointment is this week, okay? If you're watching on YouTube, listen. What do you want a girl to do, all right? Get her hair done. I get it, okay? I see them. I see it. I see what you see. This is the case of Novak versus City of Parma, Ohio, a 2022 decision by the United States Court of Appeals for the Sixth Circuit. The opinion that the Sixth Circuit entered in this case was appealed. A writ of certiorari was submitted to the Supreme Court, and through that petition, The Onion, yes, the satirical newspaper, submitted an amicus curiae brief in support of the appellant. Now, if you don't know what an amicus curiae brief is, this is basically the layman definition, I would say, for it that I'm going to give you. It could be in a civil case, criminal case, whatever. Most commonly, amicus curiae briefs, at least the most notable ones that people really are drawn to, are ones that are submitted in the Supreme Court, but they can be submitted with leave, I know, in the Court of Appeals. I've written a few before, in state court of appeal or in federal court of appeals. Amicus curiae briefs are basically the equivalent of, if you're in a fight with someone else, okay, Reb versus Maisel, and Reb has a friend that actually has a stake in the game with respect to your rap battle, your argument against the other person, okay? Maybe let's say the other person also took their boyfriend, or maybe let's say the other person is like, I think that if you are allowed to continue doing what you're doing, my boyfriend's gonna be stolen as well. They are allowed to tap in during the rap battle and have chat that they think will be helpful to the referee, right? Deciding who wins. Understood? Amazing. So it doesn't mean that they are treated as a party. It doesn't mean that their amicus curiae brief is even considered sometimes. Every appellate court's rules with respect to amicus curiae briefs are different. Some of them, state courts, federal courts, etc., some of them require that you seek the consent of both sides of the dispute, essentially of the parties, before you're allowed to file. They have to say, yes, that's okay to file your amicus curiae brief. And if one side says no, or you don't get unanimous consent, then you have to seek consent from the court to file the amicus curiae brief, and the court could say no. It just depends. The Supreme Court, as of 2023, January 1st, 2023, they made new rules. Previously, you had to seek consent from the parties and then from the court to be able to, if the parties say no, then from the court to be able to file an amicus curiae brief with respect to a petition for certiorari. So basically you're saying, hey, please, can the Supreme Court please take this case? That's your petition, right? And you can bring, or you can file amicus curiae briefs basically urging the court, hey, you should really look at this, like, please look at this case, and this is why, okay? Or, hey, you really shouldn't look at this case, and here's why not, right? In order to do that now, you don't have to seek consent from any of the parties or from the court. You can just file. They're like, just file it within the deadline. And you would think that that would mean a lot of random bullshit amicus curiae briefs like come on the docket. Not really so much. You have to, like, the only way an amicus curiae brief is going to be considered is if it's filed pursuant to the requirements that an amicus curiae brief has to fulfill and within the deadline, blah, blah, blah. You get it, okay? Amicus curiae briefs can indeed be helpful to the court. You might think like, okay, they're obviously not going to listen to these random ass people chirping, but sometimes the amicus curiae briefs are written by either lawyers or parties who just are better at like briefing the issues, raise some excellent, phenomenal points with relation to one person's side, in support of one person's side, that maybe are better, honestly, better researched, better written, better presented than the opening brief is, or the respondent brief is by either side, either party. There have been many a time where a Supreme Court opinion or any kind of court opinion that allows, or court that allows amicus curiae briefs, they have cited directly from amicus curiae briefs before. They have pulled from them. They have talked about them in the footnotes. They do read them. They don't read all of them, obviously, but I do believe that there is, and I think any lawyer would believe that there is merit and worth to amicus curiae briefs. There's my long monologue, trying to make it understandable, I guess. This case started with a Facebook page, led to an arrest, trial, ultimate acquittal, which resulted in a lawsuit that ended all the way at the Supreme Court. And in that ending, which I believe is incorrect, an amicus curiae brief was filed that I believe is truly one of the highlights of being in this profession, in this career. Let's buckle up and get started. I am going to fast forward to the point in time where the lawsuit was on appeal, okay? So skip over the page, the arrest, the trial, the acquittal. We're getting to the lawsuit. Okay, didn't like the opinion issued at the trial court, district court, and federal court, and so they appealed up to the Sixth Circuit. This is an excerpt, an exact quote from the decision, a terrible decision, mind you, in the city of Parma, Ohio versus Novak. Quote, Anthony Novak thought it would be funny to create a Facebook page that looked like the Parma Police Department's. The department was not amused. In fact, officers arrested Novak and prosecutors charged him with a state crime. Novak was acquitted at trial, and he now argues his constitutional rights were violated in the ordeal. But because the officers reasonably believed they were acting within the law, Novak can't recover. Quote unquote, that is wrong. In my opinion, that is incorrect. Under the law, I also believe that is incorrect. This man made fun of the police department on Facebook back in 2016. In March 2016, Parma, Ohio resident Anthony Novak created a Facebook page mimicking that of the Parma Police Department, except with their slogan of, quote, "We know crime," KNOW, changed to "We Know Crime NO" in the About section. He did so anonymously from his phone while waiting for a bus to express his criticism of the department's policies. Now, some bells should be ringing, some lights should be going off in your head here. What does this sound like? Parody. It is. Exactly that. What other places also engage in parody? The Onion, the Babylon Bee, okay? You know, those places, those websites, those newspapers that pretend to be what they're not, to make fun of the things that they're making fun of. Right. Is parody legal? Yes. What is it legal under? The First Amendment. Correct. You are allowed to parody. I can hop online and pretend to be Donald Trump. I can make an entire account pretending to be him and tweet things that I believe are a criticism parody of him, and that is not illegal. That is not illegal. A few people being confused does not mean that that is not free speech, that that is not allowed speech. Okay? You can understand why that would be, right? Right. Perfect. Posts on the page included job postings that discouraged applications by members of minorities and an offer of, quote, free abortions for teenagers provided by police in the Walmart parking lot. Novak took the page down after about 12 hours, during which time 10 people reported it to the police via 911. Because of course they did. When the police department posted to their real page, warning people about his page, he made the same warning on his, which is, again, funny and also parody, okay? That is parody. That's what that is. Quote, unsure what sort of case they had, as in the police are like, how do we make this how do we literally throw someone in jail over this? The Sixth Circuit said, as if they really believe they might have a valid case, quote, the cops consulted the city's law director. Don't know who a law director is. Would love to hear what they got in con law class. What grade did you get, babes? What was that looking like? Because there's no way. He, quote, concluded they had probable cause to charge Novak with a crime, specifically, quote, illegal use of a computer to disrupt or impair police functions. And somehow, two judges both agreed with this and issued warrants. The state of the world has been in decline for quite some time with respect to First Amendment principles, okay? And when I say the world, I mean the United States of America, mostly because of the misapplication of law across several jurisdictions. Like, I don't understand how literally where you are in the country can just result in the most wildly different outcomes. I mean, I can't understand it, all right? It's something that the law seeks to try to combat and prevent, but at this point, like, it truly makes me want to lose my mind. Police arrested Novak, searched his apartment, and took his phone and laptop. He was acquitted and then very understandably sued the hell out of the city and the officers involved. But the district court, the trial court at the federal level that he filed his lawsuit in, tossed out his case. And the Sixth Circuit, in the opinion I just read from, affirmed. Why? Qualified immunity, that hilarious doctrine that protects officers from lawsuits for violating a federal right unless, quote, the unlawfulness of their conduct was clearly established at the time they acted. Now, while that theory, all right, everything's great in theory, isn't it? The theory behind this doctrine, the doctrine of qualified immunity, sounds like it makes sense, like it's logical, okay? The way the law has developed is utterly insane. And I have touched on it throughout several cases on this podcast. To clarify, qualified immunity holds that an officer accused of violating someone's statutory or constitutional rights is not liable if the right in question was not, quote, clearly established at the time of the alleged misconduct. Qualified immunity has been applied so broadly that officers have been let off the hook for some pretty outrageous things just because a court had not yet specifically held that those specific things weren't okay. The way that this law has developed has basically said that it is the most niche specific, the exact just minute, second by second arrangement, sequence of events that happen to the person whose rights are being violated. If those exact sequence of events have not exactly happened to someone else, then I guess, the officer, how are they supposed to know that they were violating someone's rights? Like, we didn't say that someone didn't have a right to not be dragged out of their car, thrown on the ground, handcuffed, tasered in the crotch, and then taken to jail. Like, we've never ruled on a case like that before. Yeah. I'm being serious. Those are the types of scenarios how I guess qualified immunity has developed. I believe in the negative to unjustly protect police officers to the peril of literally everyone else. Police officers essentially are treated like they are stupid, which they often can be, okay? But under qualified immunity doctrine, they're treated like they have empty heads, just brains filled with nothing relevant or important or basic or common sense, or even filled with the law that they're required to know, okay, to do their jobs. But then qualified immunity suddenly says, oh, well, like, how are they supposed to know the law? Then there have been a just treasure trove of examples of things that police officers have done and they have been protected against, I guess, essentially being sued for, okay, because of qualified immunity, that have absolutely been rallying cries over and over again, petitioning the Supreme Court, petitioning every court to try to modify, to try to remedy qualified immunity, to modify it, to make it so that it's not so damn broad. These are just a few cases that demonstrate how bad it has truly gotten. Corbett versus Vickers, 11th Circuit, 2019. Qualified immunity granted for officer who, hunting a fugitive, ended up at the wrong house and forced 6 children, including 2 children under the age of 3, to lie on the ground at gunpoint. The officer tried to shoot the family dog, but missed and shot a 10-year-old that was lying face down 18 inches away from the officer. The court held that there was no prior case where an officer accidentally shot a child laying on the ground while the officer was aiming at a dog. So the officer got off, couldn't be sued, kept their job, not even in trouble. Jessup versus City of Fresno, 9th Circuit, 2019. Qualified immunity granted for officers who stole hundreds of thousands of dollars in cash and rare coins from a person while executing a search warrant. The court held that the theft was morally reprehensible, but could find no prior case that addressed these exact specific circumstances. So how were the officers supposed to know that this was a violation of someone's rights? Yeah, I'm being dead serious. Doe versus Woodard, 10th Circuit, 2019. Qualified immunity granted for social worker who strip searched a preschooler without a warrant and photographed her naked body. Oh, God. using a county-issued cell phone. The social worker never told the child's mother about the search, and the mother only learned of the search when the child told her mother that she hoped not to see the social worker because, quote, "I don't like it when she takes all my clothes off." The court could find no prior case with similar facts. Young versus Borden, 11th Circuit, 2017. Qualified immunity granted to officers who, without a warrant, started banging on an innocent man's door without announcing themselves in the middle of the night. When the man opened the door holding his lawfully owned handgun, officers opened fire, killing him. One dissenting judge wrote that if these actions were permitted, quote, "then the Second and Fourth Amendments are having a very bad day in this circuit." Qualified immunity was indeed granted. Estate of Smart versus City of Wichita, 10th Circuit, 2020. Qualified immunity granted for officer who heard gunshots and fired into a crowd of hundreds of people in downtown Wichita, shooting bystanders and killing an unarmed man who was trying to flee the area. The court held that the shooting was unconstitutional, but there was no clearly established law that police officers could not, quote, "open fire on a fleeing person they perhaps unreasonably believed was armed in what they believed to be an active shooter situation." AM versus Holmes, 10th Circuit, 2016. Qualified immunity granted to officers who arrested a child for burping in gym class, despite state law providing that officers could not arrest school children for, quote, "noises or diversions that merely, quote, disturb the peace or good order of individual classes." Because there had not been a case about a burping child, despite the fact that the law was indeed clearly established, this officer is protected. You getting the trend? Allah versus Milling. Qualified immunity granted for prison guards who kept a man awaiting trial on drug charges in extreme solitary confinement for 7 months. His alleged misconduct was asking to speak with a lieutenant about why he was not allowed to visit commissary. The court held that his constitutional rights were violated, but there were no prior cases concerning the particular practices employed by the prison. Seems like this is a bad standard, don't you think? Thompson versus Rahr, 2018, in the 9th Circuit. Qualified immunity granted for a police officer who, during an ordinary traffic stop, pointed a gun at the driver's head and threatened to kill him if he didn't surrender on weapons charges. There was no prior case sufficiently on point to deny qualified immunity. Kelsey versus Ernst, 8th Circuit, 2019. Qualified immunity granted to a police officer who grabbed a 5-foot-tall, 130-pound woman in a bear hug and body slammed her to the ground, breaking her shoulder and knocking her unconscious. The woman was neither fleeing nor resisting arrest, and she posed no threat to the officer or anyone else. The court held that it was not clearly established that an officer couldn't use a takedown maneuver under those specific circumstances, where she was not fleeing or resisting arrest. Baxter versus Bracey, 6th Circuit, 2018. Qualified immunity granted for officers who sent a police dog to attack a man who had already surrendered and was sitting on the ground with his hands in the air. The court held that a prior case holding it unconstitutional to send a police dog after a person who surrendered by laying on the ground was not sufficiently similar to this case involving a person who surrendered by sitting on the ground with his hands up. I just feel like it's either that everyone is in psychosis or I'm in psychosis. That's how it feels to read any qualified immunity case. These are just a sample, right? Like these are just a few. And most of them are from, late 2010s. Deep breaths, deep breathing. Brennan versus Dawson, 6th Circuit, 2018. In an effort to administer an alcohol breath test to Brennan, who was on misdemeanor probation, Officer Dawson violated Brennan's Fourth Amendment rights. Officer Dawson parked his car in front of Brennan's home with his lights and sirens blazing for over an hour. Officer Dawson then circled Brennan's home 5 to 10 times. Officer Dawson also peered into the windows of Brennan's home, as well as knocking on the windows. Officer Dawson covered the home security camera with police tape. Brennan ultimately blew a 0.00 into the breathalyzer. While this was clearly a violation of Brennan's well-established Fourth Amendment rights, Officer Dawson, you guessed it, was granted qualified immunity. Zade versus Robinson, 5th Circuit, 2019. Officers barged into a doctor's office without previous notice or a search warrant before demanding access to medical records of 16 patients. The officers involved in the unethical and illegal search were granted qualified immunity. White versus Pauley, the Supreme Court, in 2017. After an alleged road rage accident, 3 officers arrived at Mr. Pauley's house where he lived with his brother. Rather than announce their presence, they approached the house in a covert manner. When the brothers became aware that there was someone on the property, they asked, quote, "Who are you and what do you want?" Without explaining that they were police officers, the officers yelled to Mr. Pauly and his brother, who remained inside their home, "Hey, slur, we have you surrounded." Officers then stated, "State police opened the door." Without giving the reason for their presence, as the police were behind a closed door outside of the home, all the brothers heard were one of the officers demanding, open the door, and we're coming in." The brothers were still unaware that it was police officers surrounding their home. In an effort to protect themselves, the brothers yelled, quote, "We have guns," to hopefully ward off the intruders. The brothers fired a warning shot before one of the officers shot and killed one of the brothers without probable cause in the first place to go to the brothers' property, other than an alleged road rage incident that the officers basically killed a man because of that, and they were granted qualified immunity. So that's the sample that you got, all right? So, of course, in this instance, you can imagine that this person, okay, our parody Facebook account man, Novak, who ran this and said, "Hi, these were my First Amendment rights," okay, and was acquitted. He's going to file a lawsuit against these officers, basically saying, "You were pissed off because I was making fun of you." This page was up for 10 hours, mind you, okay? And sorry, a few people were confused. That doesn't mean that my First Amendment rights can't also be exercised. You're insane and crazy. You violated my rights by claiming that I was interviewing or interfering with police business when I was not. So what did the officers say? Qualified immunity, of course. That's the defense, because it's worked literally every single time before. So why not now? Yeah. Among other things, the Sixth Circuit agreed with the officers, said, yeah, qualified immunity. They pointed out that Novak hadn't just posted fake stories mocking the police department. He had also modeled his page after the department's and, quote, deleted comments that let on his page wasn't the official one. In other words, the Sixth Circuit criticized a parodist for making his parody look like the original. That is how parody works. Indeed it is. I know that this might sound, okay, on the surface, like, ooh, yeah, I don't know about that. Is that really something that we can combat here? I mean, yeah, it does sound like it's interfering. No, just because it's a police department doesn't mean that you're not allowed to parody them online. That is what parody is. First Amendment. Okay? Perfect. We have separate and specific laws relating to people dressing up as police officers and pretending to be police officers, putting sirens on their cars, right? Those are separate laws that are already addressed. They're already addressing those issues. You can't look at a First Amendment issue and then immediately go, well, it's the same thing as dressing up as police officer. No, it's not. It's quite literally not. It is quite literally not. That is how parody works. And no one knows that better than The Onion, which is, if you don't know, you should definitely be up to speed. Type in The Onion, take a gander, take a look. They are a parody newspaper. They have been parodying brilliant things brilliantly for a long time now. So who better to explain this concept of parody and the First Amendment to the Supreme Court, which is where this case ended up after Novak's lawsuit was essentially dismissed based on qualified immunity, okay? Basically, The Onion clocked in when Novak filed a petition for writ of certiorari with the Supreme Court, to have the Supreme Court review the case to say, hey, if you take this case on, rule that, yes, this is a violation of the First Amendment. Rule that, yes, parody is, of course, included in the First Amendment. Please and thank you. Why, you may ask? Well, because they have a stake in the game. You understand how Amicus curiae briefs work. But in this instance, okay, the idea behind The Onion even filing an Amicus curiae brief, okay, was the first of its kind. They had never done so in a case before this, ever. In the history of The Onion, they hadn't done that yet, okay? What I'm about to read to you is the real life, actually filed, not a joke. Well, it is a bit of a joke, but it's also incredibly sincere because it's highlighting how stupid it is to not rule in favor of the First Amendment in this regard. Yes, qualified immunity is a different damn beast, okay, that we need to tackle, as demonstrated by the cases that I spoke about, that I gave you examples of, all right? But with respect to whether, like, the question that basically the Sixth Circuit and the lower court added to their analysis, dismissing this lawsuit on qualified immunity grounds, they basically implied that this actually wasn't rightful parody. Incorrect. Extremely loud. Incorrect buzzer. No, you got that wrong, and let's get it clear, okay? Let's get that clear and consistent, okay? Since you can't get qualified immunity to mean anything other than just police can get away with breaking every law, every right, every moral principle we have in society in the book. We got that, okay? Gathered. We got that part. Amazing. Keep that up for sure. Sarcasm. At the very least, don't include in your opinion that this isn't clearly protected First Amendment activity, okay? Goodbye. The Onion did this so beautifully, so brilliantly, so concisely. I genuinely have no way of giving it to you in a summarized form other than reading it to you word for word. Yes, this was filed with Supreme Court. Yes, it is. Google it. Googly doogly. Brief of the Onion as amicus curiae in support of petitioner. Filed by Stephen J. Van Stemfort, Counsel of Record, D. Andrew Portinga of Miller Johnson, 45 Ottawa Avenue in Grand Rapids, Michigan. If you are here and listening in, these two attorneys, I salute you. I really do. What is their interest, right? Because amicus curiae filers do need to state their interest in the case, okay, to be taken seriously. So this is what their interest is. The Onion is the world's leading news publication, offering highly acclaimed, universally revered coverage of breaking national, international, and local news events. Rising from its humble beginnings as a print newspaper in 1756, The Onion now enjoys a daily readership of 4.3 trillion and has grown into the single most powerful and influential organization in human history. In addition to maintaining a towering standard of excellence to which the rest of the industry aspires, The Onion supports more than 350,000 full and part-time journalism jobs in its numerous news bureaus and manual labor camps stationed around the world, and members of its editorial board have served with distinction in an advisory capacity for such nations as China, Syria, Somalia, and the former Soviet Union. On top of its journalistic pursuits, The Onion also owns and operates the majority of the world's transoceanic shipping lanes, stands on the nation's leading edge on matters of deforestation and strip mining, and proudly conducts tests on millions of animals daily. I am doing my very damned best to not laugh as I read this. Just a quick aside, okay? Can we pause the reading for a minute to explain to you? This is my audition tape, my first acting debut, all right? I hope that you will bear with me with the straight face that I'm working on, okay? Acting coach included. This is my debut, all right? This is my film, this is my self-tape. The Onion's keen, fact-driven reportage has been cited favorably by one or more local courts, as well as Iran and the Chinese state-run media. Along the way, The Onion's journalists have garnered a sterling reputation for accurately forecasting future events. One such coup was The Onion scoop revealing that a former president kept nuclear secrets strewn around his beach home's basement 3 years before it even happened. That's correct. If you guys didn't know, in 2017, The Onion posted a parody article that said, quote, Mar-a-Lago assistant manager wondering if anyone coming to collect nuclear briefcase from Lost and Found. March 27, 2017. What everyone, hopefully listening to this podcast knows, and if you don't, here you go. Here's some education. What later happened is Trump actually was found to have kept a bunch of top secret classified documents, all right, in bathroom at his Mar-a-Lago home. Like, the thing was raided, all right? He was keeping all this shit literally strewn about years later. Listen, I'm not a rocket scientist or anything, but I do believe that in the state of America now, I'm shocked every time an Onion article ends up being false. If you want me to be honest, every time I see a headline from them now, I have to double, triple, quadruple check that it's actually them. 90% of the time when I see any headline now from a legitimate news source, I assume that it's The Onion and keep it moving. And then I have to scroll back up and go, wait, no, it's not. Let's keep going. The Onion files this brief to protect its continued ability to create fiction that may ultimately merge into reality. As the Globe's premier parodists, The Onion's writers also have a self-serving interest in preventing political authorities from imprisoning humorists. This brief is submitted in the interest of at least mitigating their future punishment. Next heading, Introduction and Summary of Argument. Americans can be put in jail for poking fun at the government? ? This was a surprise to America's finest news source, in all capitals, and an uncomfortable learning experience for its editorial team. Indeed, quote, Ohio police officers arrest, prosecute man who made fun of them on Facebook, end quote, might sound like a headline ripped from the front pages of The Onion, albeit one that's considerably less amusing because its subjects are real. So, when The Onion learned about the Sixth Circuit's ruling in this case, it became justifiably concerned. First, the obvious. The Onion's business model was threatened. This was only the latest occasion on which the absurdity of actual events managed to eclipse what the Onion staff could make up. Much more of this, and the front page of The Onion, would be indistinguishable from the New York Times. Second, The Onion regularly pokes its finger in the eyes of repressive and authoritarian regimes, such as the Islamic Republic of Iran, the Democratic People's Republic of North Korea, and domestic presidential administrations. So, The Onion's professional parodists were less than enthralled to be confronted with a legal ruling that fails to hold government actors accountable for jailing and prosecuting a would-be humorist simply for making fun of them. Third, the Sixth Circuit's ruling imperils an ancient form of discourse. The court's decision suggests that parodists are in the clear only if they pop the balloon in advance by warning their audience that their parody is not true. But some forms of comedy don't work unless the comedian is able to tell the joke with a straight face. Parody is the quintessential example. Parodists intentionally inhabit the rhetorical form of their target in order to exaggerate or implode it, and by doing so, demonstrate the target's illogic or absurdity. Put simply, for parody to work, it has to plausibly mimic the original. The Sixth Circuit's decision in this case would condition the First Amendment's protection for parody upon a requirement that parodists explicitly say up front that their work is nothing more than an elaborate fiction, but that would strip parody of the very thing that makes it function. The Onion cannot stand idly by in the face of a ruling that threatens to disembowel a form of rhetoric that has existed for millennia, that is particularly potent in the realm of political debate, and that, purely incidentally, forms the basis of the Onion writers' paychecks. The next heading is their argument. Parody, heading number one in their argument is parody functions by tricking people into thinking that it is real. Tu stultus es. You are dumb. These three Latin words have been The Onion's motto and guiding light since it was founded in 1988 as America's finest news source, leading its writers toward the paper's singular purpose of pointing out that its readers are deeply gullible people. The Onion's motto is central to this brief for two important reasons. First, it is Latin, and The Onion knows that the federal judiciary is staffed entirely by total Latin dorks. They quote Catullus in the original Latin in their chambers. They sweetly whisper stare decisis into their spouse's ears. They mutter cui bono under their breath while picking up after their neighbor's dog. So The Onion knew that unless it pointed to a suitably Latin rallying cry, its brief would be operating far outside the court's vernacular. The Supreme Court presumably read this. The second reason, perhaps mildly more important, is that the phrase, quote, you are dumb, captures the very heart of parody, tricking readers into believing that they're seeing a serious rendering of some specific form, a pop song lyric, a newspaper article, a police beat, and then allowing them to laugh at their own gullibility when they realize that they've fallen victim to one of the oldest tricks in the history of rhetoric. The very nature of parody is to catch the reader off guard at first glance, after which the victim recognizes that the joke is on him to the extent that it caught him unaware. It really is an old trick. The word, quote, parody stretches back to the Hellenic world. It originates in the prefix para, meaning an alteration, and the suffix ode, referring to the poetry form known as an ode. One of its earliest practitioners was the 1st century BC poet Horace, whose satires would replicate the exact form known as an ode, mimicking its meter, its subject matter, even its self-serious tone, but tweaking it ever so slightly so that the form was able to mock its own idiocies. This is not a mere linguistic anecdote. The point is, instead, that without the capacity to fool someone, the parody is functionally useless, deprived of the tools inscribed in its very etymology that allow it, again and again, to perform this rhetorically powerful sleight of hand. It adopts a particular form in order to critique it from within. How obsessed are you with this writing, just first and foremost? Excellent, exquisite legal writing from the Onion's attorneys. I can't say enough. This brief is perfect. Parody leverages the expectations that are created in readers when they see something written in a particular form. This could be anything, but for the sake of brevity, let's assume that it is a newspaper headline, maybe one written by The Onion, that begins in this familiar way. Quote, Supreme Court rules ... Already, one can see how this works as a parodic setup, leading readers to think that they're reading a newspaper story. Obsessed with how they're breaking this down just line by line, because yes, it does sound as stupid as it actually is to assume that parody does not exist within our First Amendment framework. Like, hello, they're like, hi, do you want me to explain why this headline, this fake Onion headline is funny? Okay, we'll do it now with y'all that we're literally filing this brief to the Supreme Court. I love it. I love it, and I want them to do it more. And again, in every case even. That would be perfect. Thank you so much. Already, one can see how this works as a product setup, leading readers to think that they're reading a newspaper story. With just 3 words, The Onion has mimicked the dry tone of an Associated Press news story, aping the clipped syntax and the subject matter. The Onion could go even farther by putting that headline on its website, which features a masthead and Latin motto, and the design of which parodies the aesthetics of major news sites, further selling the idea that this is an actual news story. Of course, what moves this into the realm of parody is when The Onion completes the headline with the punch line, the thing that mocks the newspaper format. The Onion could do something like, quote, Supreme Court rules, Supreme Court rules. The Onion could push the parody even further by writing the joke out in article format with, say, a quote from the justices in the majority, opining that, quote, while the U.S. Constitution guarantees equality of power among the executive, legislative, and judicial branches, it most definitely does not guarantee equality of coolness, end quote. And rounding off by reporting the Supreme Court's holding the court, quote, rules and rules totally, all worthy and touched by nobody, in perpetuity and in accordance with Article 3 of the U.S. Constitution. The ability of the President and Congress to keep pace with us is not only separate, but most unequal. End quote. As can be seen, the Associated Press form is followed straight through into the article. That rhetorical form sets up the reader's expectations for how the idiom will play out, expectations that are jarringly juxtaposed with the content of the article. The power of the parody arises from that dissonance into which the reader has been drawn. And mind you, too, as an aside, they are citing 2 legitimate court cases addressing parody throughout this, okay? So don't think that they're just talking about parody as if it's not actually a legally recognized thing. It absolutely is. It absolutely is. Here's another example. Assume that you are reading what appears to be a boring economics paper about the Irish overpopulation crisis of the 18th century, and yet, strangely enough, it seems to advocate for solving the dilemma by cooking and eating babies. That seems a bit cruel until you realize that you in fact are reading a modest proposal. To be clear, The Onion is not trying to compare itself to Jonathan Swift. Its writers are far more talented, and their output will be read long after that hack Swift's has been lost to the sands of time. Still, The Onion and its writers share with Swift the common goal of replicating a form precisely in order to critique it from within. That leverage of form, the mimicry of a particular idiom in order to heighten dissonance between form and content, is what generates parody's rhetorical power. They cite to a Supreme Court case from 1994, Campbell versus Akufaro's Music Incorporated, quote, parody needs to mimic an original to make its point, end quote. If parody did not deliver that advantage, then no one would use it. Everyone would simply draft straight, logical, uninspiring legal briefs instead. Heading number 2. Because parody mimics the real thing, quote unquote, it has the unique capacity to critique the real thing. Importantly, parody provides functionality and value to a writer or a social commentator that might not be possible by, say, simply stating a critique outright and avoiding all the confusion of readers mistaking it for the real deal. One of parody's most powerful capacities is rhetorical. It gives people the ability to mimic the voice of a serious authority, whether that's the dry newspeak of the Associated Press or the legalese of a court's majority opinion, and thereby kneecap the authority from within. Parodists can take apart an authoritarian's cult of personality, point out the rhetorical tricks that politicians use to mislead their constituents, and even undercut a government institution's real-world attempts at propaganda. Time and time again, that is what has occurred with The Onion's news stories. In 2012, for example, The Onion proclaimed that Kim Jong-un was the sexiest man alive. China's state-run news agency republished The Onion story as true alongside a slideshow of the dictator himself in all his glory. The Fars Iranian news agency uncritically picked up and ran with The Onion's headline, quote, Gallup poll, rural whites prefer Ahmadinejad to Obama, end quote. Domestically, the number of elected leaders who are still incapable of parsing The Onion's coverage as satire is daunting, but one particular example stands out. Republican Congressman John Fleming, who believed that he needed to warn his constituents of a dangerous escalation of the pro-choice movement after reading The Onion's headline, quote, Planned Parenthood opens $8 billion abortion flex. The point of all this is not that it is funny when diluted figures of authority mistake satire for the actual news, even though that can be extremely funny indeed. Rather, it's that the parody allows these figures to puncture their own sense of self-importance by falling for what any reasonable person would recognize as an absurd escalation of their own views. In the political context, the effect can be particularly pronounced. Quote, nothing is more thoroughly democratic than to have the high and mighty lampooned and spoofed. That is an exact quote from a dissenting opinion in Falwell versus Flint in 1986. The third heading in this brief, in this argument, is, quote, a reasonable reader does not need a disclaimer to know that parody is parody. At bottom, parody functions by catering to a reasonable reader, one who can tell, even after being tricked at first, that the parody is not real. If most readers of parody didn't live up to this robust standard, then there would be nothing funny about the Chinese government believing that a pudgy dictator like Kim Jong-un was the sexiest man on earth. Everyone would just agree that it was perfectly reasonable for them to be taken in by the headline. The law turns on the same reasonable person construct, which is the foundation of parody and First Amendment law. The reasonable reader test gauges whether a statement can reasonably be interpreted as stating actual facts, thereby ensuring that neither the least humorous nor the most credulous audience dictates the boundaries of protected speech. Can I get a snap for that? Thank you. The Onion hitting the jokes and the absolutely correct legal analysis. Thank you. Do you understand why? The fact that 10 people called 911 on this guy Novak's Facebook page, that was parody, okay? The fact that they called 911 about it, that those people believed that it was 100% real, even though they could have read the about me and been like, okay, this is clearly not real. We cannot have our rights, our First Amendment rights, run by idiot morons, by the extremes on either side of the IQ ability to pick up on sarcasm standard. I'm sorry. Yes, there are people who won't be able to. Yes, there might be a few things slipping through the cracks, but that is not the reasonable person standard. The reasonable person standard is the standard that we use for most things, because if we really lived and died by what the extreme end of our people, okay, our populace thought or assumed or believed about something, we wouldn't be able to say a goddamn word. Snap, snap, snaps. Sometimes because some of y'all aren't funny, but sometimes because parody should be protected. Now, I know this is starting to sound like it's getting into the weeds of legal analysis and rulesy, and it totally is, but damn, does it make so much sense? The Onion should be doing this more often, I fear. Context matters, but even a poorly executed parody is ordinarily susceptible to the intellectual grasp of the reasonable reader. This fictional, hypothetical, reasonable reader is who we live and die by, okay? And we need to make damn sure that they at least have the tools to do the things that reasonable people would, okay? We literally live by this hypothetical person, all right? This reasonable hypothetical person. And God, as time goes on, Sometimes I fear that they're getting a little bit more unreasonable, but whatever. Neither here nor there. Reasonable readers do not need to be told explicitly what they have no serious trouble figuring out for themselves. And until the Sixth Circuit's decision, that is what most courts have held. Period. Okay? Period. This is not crazy. This should not have been news. Some courts have expressly held that disclaimers aren't required for parody to be protected. Campbell, for example, noted that, quote, there is no reason to require parody to state the obvious or even the reasonably perceived. And Campbell was a Supreme Court case. Other courts have held that parody published without a disclaimer is nonetheless protected speech. For example, in New York Stock Exchange versus Gahary in 2002, the district court found it entirely plausible that no one in their right mind would believe that the defendant, who posted obscene and vulgar messages online under the persona Richard Grasso, was the real-life Richard Grasso, the CEO of the New York Stock Exchange. In this case, by contrast, because we somehow, for some reason, treat cops differently, the Sixth Circuit ruled that the defendant officers, quote, could reasonably believe that some of Novak's Facebook activity was not parody, primarily because Mr. Novak, quote, deleted comments that made clear the page was fake, end quote. But the lack of an explicit disclaimer makes no difference to whether a reasonable reader would discern that this speech was parody, as demonstrated above. Just to be clear, this was not a close call on the facts. Mr. Novak's spoof Facebook posts advertised that the Parma Police Department was hosting a, quote, pedophile reform event in which successful participants could be removed from the sex offender registry and become honorary members of the department after completing puzzles and quizzes. Okay, stop laughing. That the department had discovered an experimental technique for abortions and would be providing them to teens for free in a police van. And that the department was banning city residents from feeding homeless people in a, quote, attempt to have the homeless population eventually leave our city due to starvation, end quote. True. Not all humor is equally transcendent, but the quality and taste of the parody is irrelevant. Thank you. And there is no real doubt that reasonable readers would have no difficulty in ascertaining that Parma's finest were not actually providing free abortions. Why are all of those funny? They're funny because they are critical of the police department by being it. They're critical of it by being the extreme of it. I do indeed think they're funny. But even if you don't think that they're funny, that doesn't matter. And The Onion says this as well. True. Not all humor is equally transcendent, but the quality and taste of the parody is irrelevant. And they quote to a 10th Circuit case in 1982, which says that they extended First Amendment protections to a parody that had, quote, no redeeming features whatsoever. So even if your shit is just a bust, just not funny at all, crickets, okay, booed out of the stadium, that is also protected. You can, unfortunately for literally everyone else, unfunny bitches are protected. Stay safe out there, all right, all of y'all, because if they weren't, I would be fine. I'd be just fine. Can't say the same for most of the men with microphones and podcast equipment on the internet, but that's neither here nor there. And there is no real doubt that reasonable readers would have no difficulty in ascertaining that Parma's finest were not actually providing free abortions to teens in a police van, pardoning child sex offenders on the basis of their adeptness at puzzles, or intentionally starving the homeless. The absence of a disclaimer lends nothing to the analysis. Under a proper understanding of the reasonable reader test, a disclaimer not only spoils the punchline, but is redundant. The Sixth Circuit's holding stands alone among the otherwise uniform approach courts have taken, and not in a good way. We are now on the fourth heading of their argument. Quote, it should be obvious that parodists cannot be prosecuted for telling a joke with a straight face. This is the 15th page of a convoluted legal filing intended to deconstruct the societal implications of parody, so the reader's attention is almost certainly wandering. That's understandable. So here is a paragraph of gripping legal analysis to ensure that every jurist who reads this brief is appropriately impressed by the logic of its argument and the lucidity of its prose. Bona vacantia, de bonis aspertatis, writ of certiorari, de minimis, jus accrescendi, forum non convenient, corpus juris, ad hominem tu coque, post hoc ergo propter hoc, code s demonstradum, actus reus, scandalum magnatum, pactum reservati domini. See what happened? This brief itself went from a discussion of parody's function and the quite serious historical and legal arguments in favor of strong protections for parodic speech to a curveball mocking the way legalese can be both impenetrably boring and belie the hollowness of a legal position. That's the setup and punchline idea again. It would not have worked quite as well if this brief had said the following. Hello there, reader. We are about to write an amicus brief about the value of parody. Buckle up, because we're going to be doing some fairly outrageous things, including commenting on this text form itself. Taking the latter route would have spoiled the joke and come off as more than a bit stodgy. But more importantly, it would have disarmed the power that comes with a forum devouring itself. For millennia, this has been the rhythm of parody. The author convinces the readers that they're reading the real thing, then pulls the rug out from under them with the joke. The heart of this form lies in that give and take between the serious setup and the ridiculous punchline. As Mark Twain put it, quote, the humorous story is told gravely. The teller does his best to conceal the fact that he even dimly suspects that there is anything funny about it. Not only is the Sixth Circuit on the wrong side of twain, but grafting onto the reasonable reader test a requirement that parodists explicitly disclaim their own pretense to reality is a disservice to the American public. It assumes that ordinary readers are less sophisticated and more humorless than they actually are. Although parody is often offensive, quote, it is nevertheless deserving of substantial freedom, both in entertainment and as a form of social and literary criticism. This court has traditionally been hesitant to chill speech, and the prospect of chilling parody by imprisoning its practitioners provides equal cause for caution. Quote, what may be difficult to communicate or understand when factually reported may be poignant and powerful if offered in satire. The last thing we need, this is a quote from the 10th Circuit in 1996. The last thing we need, the last thing the First Amendment will tolerate is a law that lets public figures keep people from mocking them, end quote. Thank you. Thank you so much. Can you believe that this episode is completely irrelevant to what's happening in our modern time today? Right. The Onion intends to continue its socially valuable role, bringing the disinfectant of sunlight into the halls of power. And it would vastly prefer that sunlight not be measured out to its writers in 15-minute increments in an exercise yard. That is the end. The conclusion? The petition for writ of certiorari should be granted, the rights of the people vindicated, and various historical wrongs remedied. The Onion would welcome any one of the three, particularly the first. You ate that, you chewed it, you devoured it. October 2022. This case did not result in the first thing that they asked for, nor the second or the third. But that's showbiz, baby. The petition for writ of certiorari was denied by the Supreme Court. They refused to hear the case. So the opinion issued by the Sixth Circuit did stand. The opinion did not somehow alter parody law in some substantial respect. It was very much a ruling on qualified immunity. However, it was not good. And yes, if you were wondering, the entirety of the Onion's brief and their point and their legal arguments are still current today. Like, that is on paper, the law with respect to parody, First Amendment, all of that. That is what our country has historically protected, regardless of what is presently happening currently right now. What is happening now in our country is a refusal to adhere to so many different aspects of very well-established constitutional law and precedent and just basic principles of legal analysis and fucking common sense. It is difficult to be an attorney in these days and have people always ask you, well, can they do that? Well, are they allowed to do that? Well, isn't this legal? Well, isn't this wrong? Well, isn't this a violation of this amendment and that amendment and another amendment? And you're like, well, all three actually. Yeah. No, they can't do all of those things. Yes, it's a violation of everything you just said. But unfortunately, we are in a system where it can only operate effectively if all three branches are adhering to what the laws say. So that's what I have to say about that presently. But it's really not changed. Y'all know how I feel, okay? We are in some times, that's for sure. Fill in the adjective before the word times as you see fit. But I hope you got at least a giggle out of this brief. And hope, fingers crossed, the Onion can tap into a few more before they are indeed in the jail yard, having their 15-minute interval breaks for their recesses, okay? For their rec time, when we're all in prison for the things we say on this podcast, on the Onion website. Yeah, hopefully they get a few amicus briefs in. Hopefully they have a few more out of them before giggling becomes a crime. Love y'all so much. Stay safe. New episode coming very soon. Kisses. Hope you loved it. And yes, you can read the actual Onion brief, start to finish, top to bottom, head to foot, hair to piggy toes online. I will link it in the show notes below. Love you. Bye.